Is President Biden's $430 billion student debt relief plan doomed at the Supreme Court? Well, it was a hot topic this week, and after nearly 4 hours of oral argument, plenty of members of the Supreme Court press have some thoughts, including our friend and friend of the show, James Romoser, the editor of SCOTUSblog. I got a chance to catch up with him this week. Take a listen.
Thank you so much for joining us on In the Courts, coming back again. This is obviously a huge week at the Supreme Court with student loans. Millions of Americans are watching this case, but it's really two cases. And our audience knows we've talked about this. One issue is whether the people who are challenging the law get to even have a foot in the door in the courtroom before we even get to the merits of President Biden's plan. So I want to get your read on that first question. Do the challengers actually have the right to be in court here?
Yeah, that's right, Katie. What you're referring to is a principle called legal standing. And it's essentially a rule that says you don't have a right to sue over any policy just because you don't like it. You actually have to show that the policy is creating a direct injury or the threat of some direct imminent injury in the future on you. And so the question in this case is whether the states that are challenging the Biden debt relief plan can show the threat of an imminent injury. There's a lot of questioning on the court about whether they can really show that, and I think their arguments are somewhat tenuous. Certainly the three liberal justices were very skeptical of the state's standing here, and you saw during the arguments this week that the liberals were sort of trying to talk some of the median conservatives into coming along and dismissing this case on the standing ground so that the court doesn't have to get to the merits, the substantive merits of the plan at all. And you heard people like Amy Coney Barrett at least expressing some doubt about whether the states have standing. I think the Biden administration has a path to victory here. It will be on that narrow standing ground, which would allow the court to just punt and not reach the substance.
Because presumably, if we make it to merits, it looks like there are at least 5 votes to strike down the plan, right?
Oh, I would say if it reaches the merits, there are 6 solid votes that, essentially the 6 conservative justices who expressed a lot of criticism of the plan. They talked about it as a $500 billion plan. They talked about the fairness of giving debt relief to college graduates, but not to non-college graduates who might have other types of debt. And I think on the substance, the 6 conservatives simply don't like this policy and would be ready to strike it down if they have the chance to do that.
You bring up the discussion about fairness, and the justices talk a lot about their role and the limited role of the court. And that fairness discussion felt like it was almost in the realm of policymaking. They were talking about what was fair to whom and what Americans got a piece of this pie and not. Now, Justice Gorsuch couched it a little bit in the case and in the statutory language and saying that the Secretary of Education didn't seem to consider the fairness in his justification for the program. But I just wanted to get your take briefly on the justices talking about this policy point of fairness in a case that's really about whether the Secretary of Education had the power to do this or not.
Yeah, that's right, Katie. It was quite peculiar, I guess would be one word. The Supreme Court's conservative majority has said in other types of cases, in other contexts, that they're simply neutral arbiters interpreting the law, and policy questions about what is a good policy or a bad policy or a fair policy or an unfair policy are not appropriate for the Supreme Court to consider. John Roberts has written essentially that in prior opinions. And yet, during the arguments, you heard John Roberts and his fellow conservatives literally talk at length about whether this is a fair policy. And to the extent that question and that concern comes into the court's decision, I think the only way to describe it would be to say it's inconsistent with what the court has done in other contexts.
And just quickly here at the end, I just want to ask you about your column this week, because you talked a little bit about Justice Ketanji Brown Jackson, a justice we're still learning a lot about. What have we learned from her few months on the bench?
Well, I thought it was interesting to note that it's still early, but the court has released 6 opinions in argued cases so far. The only 2 justices who have not dissented in any of those 6 are the Chief, John Roberts, and surprisingly, Ketanji Brown Jackson. I don't think that trend will persist, but I do think we see some attempts by her to be a consensus builder on the court in this very early stage.
We saw a little bit of that during oral argument too. Well, James Romoser with SCOTUSblog, thank you so much for taking the time to join us. We look forward to the next time, and perhaps when the opinion comes down in this case.
Always happy to talk to you, Katie.